Well, hello everybody. This is Denise Holliday. It's so nice to spend some time with you. I know many of you are taking this webinar as part of your CRPM class, so I'm glad you're joining us and we're ready to do some updates. When I was creating this class, my thought was, what are some things that I've seen through 2017 that I think are going to carry over to 2018? And so I'm going to spend a few minutes just talking about what these issues are. And hopefully you'll get some new insight into these issues. If I step on your toes, I'm going to ask you to pull them back just a tad. I know that we're going to talk about some issues that maybe are a little controversial, but at least think about what the information is, and then you can create your own policy. So we're going to talk about landlord-tenant issues, because that's what I do, and my concern is really what are the landlord traps that I see looming, that we've been through in the last year, but also that are coming up into this next legal year. One of the biggest issues I think we're seeing is that because the booming rental market, we have lots of good things that are happening and bad things that are happening. One of the really terrific things that we have that's happening is we're able to maybe be a little choosier, a little, more careful when we're choosing specific tenants. I can tell you that that's a wonderful thing for our market. We're able to increase our rents. We're able to potentially get some better prospects. The problem is that there are less homes. If there are less homes to rent, then sometimes when you're turning people down, that becomes a really ugly, nasty process and can result in either civil litigation or more commonly a fair housing complaint. So I'd like to spend just a few minutes right at the very beginning talking about what do we do in this process of having so many people to choose from, and how do you choose to process the leases applications that you're getting. I think the first one, the most importantly, is to set a really solid and defendable rental criteria. I think it needs to be in print. I suggest to everyone that you publish this, which means you either put it on the back of the application or you actually post it on your website, but that you let people know ahead of time, this is what we're looking for and this is really what we expect. And if you have any additional information that you think is relevant, you're more than welcome to present that as part of your application packet. But also, we're not going to process any part of your application packet until all of those items are fully included. Setting some really strong rental criteria is not as easy as it may sound. Being able to defend it is even harder. And we're going to spend a few seconds just talking about what some of the biggest issues that I've seen last year, especially in the civil litigation and the fair housing litigation. The first one is using a really good application. I like AAR's application. They have asked different questions than what we typically see. I typically see in a regular application, have you ever been evicted? And the tenant's answer is no, hurry, court's next week. And so that's not good. You really want to be asking, have you ever had a breach notice or an eviction notice? That's the most important part of the equation, not have you actually been evicted. In fact, some of you even say, have you ever had a forcible detainer filed against you? Well, a forcible detainer is actually a commercial case. So you're not even using the right word. It's called a special detainer. And we've had some very smart tenants who've been evicted a lot. Specifically look for applications that ask that word. Have you ever been convicted of a forcible detainer? The answer is, of course not. And they're not lying. So be careful about the question that you're asking about an eviction. The other question we see frequently is, do you have any pets? The answer is no. I have 14 service cats, but you didn't ask me the right question. So think about the question and how you should maybe phrase it. Do you have, or do you have any plan to have any animals? No, I don't have any animals right now. I plan to get 14 next week, but right now, today, I'm not lying. I have no animals. The reason why we say animals versus pets is a pet is a traditional animal that someone uses to make them happy. We have different types of animals and classifications. Of course, I'm talking about service animals, or more importantly, ESAs, emotional support animals. When you ask if you have a pet, they are not lying when they say, no, I do not. I have an ESA or a service animal. It is not a pet. It's like a wheelchair. So they're not lying, and you can't now take any steps to evict them or give them a breach notice. So be careful. You should ask, do you have any pets? Do you have any service animals? Do you have any animals at all? I like better, do you just have any animals currently, or are you planning to have any animals? And the last one is the typical question we've been talking about now for about 2 years is, have you ever been convicted of a crime? Their answer is no. Trial's in 3 weeks. That's not what you want to know. You want to know, have you been arrested or convicted or aware of a warrant out for your arrest? You want to know that. Now, spending a few minutes to talk about that, hopefully all of you aware that in April of 2016, HUD came out with some guidance about landlords using felony backgrounds as part of your rental criteria. Contrary to the opinion of most people, this is not a new protected category. What the HUD memorandum said, or the HUD guidance said, was you have to have a defendable position on why you're using specific information to disqualify someone. That means we want to know, have you thought about carefully how that felony conviction will impact your property? What is the risk? What has the person done before they were convicted, after they were convicted? How long ago was the conviction? Did they complete their sentence fully? Are they still on probation or parole? What type of felony? In my world, I'm much more worried about something like arson than someone who embezzled $4 million from their employer. From my world, an arson has a huge risk of problems to my client's particular property and maybe the neighboring property. So when you're creating this felony background rental criteria, you need to spend some time really thinking about and having sufficient documentation as to why you're asking certain questions and using specific information. And of course, I love the AAR's application because it actually has a section where it asks you if there's anything else you'd like me to talk about or look at, please feel free to submit that. And that's one of the suggestions that the HUD memorandum or HUD guidance actually specifically listed. I also think you need to, in this application process, listen to the applicant. Listen to the words they're using. Watch for some warning signals that may tip their hand that they're potentially going to file a suit against you. And then immediately document what happened. If you hear something from a particular applicant when you've turned them down and they say, I want to know why you rejected me. I think you rejected me based on my whatever, because I'm green, because I'm orange, because I'm disabled, because I have whatever. You need to write down and document the words they use and the true basis on which you rejected their application. You are not required to tell an applicant why you rejected their application. You should say you don't meet my rental criteria. You're also required to give them a letter that's required by some of the federal laws that involve people's credit scores, and there's a specific form out. AAR has it on their website, so do we. And if you're using a third-party vendor, they're going to automatically issue that form. But you need to think about issuing that form, and that's all. You just say you did not meet our rental criteria. Be concerned if you have something from a tenant that says, or an applicant that says, you refuse to even consider the fact that or the fact that the last landlord was lying about me, whatever that specific information. Make sure that you point out, if they use that phrase, absolutely not. As you know, we have this extra section. If you want to go back and fill it out now, fill out what it is you want me to consider. We hear very, very frequently that that's not me, that credit report's wrong, I didn't commit that crime. That slows down your ability to process the application, but you shouldn't hold this particular property off the market while the applicant is trying to get you the additional information. You would screen it as you would any other applicant that has a full file ready. And then finally, I want you to pay really careful attention if you hear someone say, if you don't rent to me, I'm going to sue you, or I'm going to file a fair housing complaint. Don't now choose to rent to them. If they were nasty and hateful while you were dating, they're going to be terrible as your spouse. So think carefully. If you have an abusive applicant, you should have a company policy that says if an applicant becomes abusive during the application process, they call you names, they use inappropriate language, they use racial slurs, they act in a threatening manner, you should automatically use it as a rental denial. That should be a policy you have written into your company policies, that if an applicant is disrespectful, aggressive, argumentative, abusive, that you automatically now have grounds to refuse service. And you should have that written as part of your company policy. Also, make sure you document whatever that decision was, how you came to that decision, what you looked at. This is not something you provide to your applicant. This is just something that you use to protect yourself and to protect the fact that you didn't do anything wrong, that you use a sound reason. And if you're not sure, reach out and talk to your attorney. And then document in your management notes that I was unsure about how to process this particular application because the applicant said they had a conviction for whatever murder, whatever period of years before, and this is what they want me to consider. I reached out to my legal counsel, and my legal counsel discussed the following things. And based on that information, I shared that with the owner, and the owner decided to not approve this application. Just write it down very clearly and concisely in your paperwork. The fact that you reached out to legal for legal advice will, in fact, be a defense in the event you have a fair housing complaint or a civil suit. One of the ongoing issues that we're seeing a lot now in 2017, I expect to continue to 2018, is you're going to have owners that no longer want to be a rental owner. They didn't want to necessarily own that property and haven't wanted to own it for a while. They don't want to deal with the air conditioning issues and the flooding issues and the non-payment of rent issues, and they've decided to sell. And while that's terrific, sometimes you are not the person who's going to be the listing agent for the sale of that property. That creates some complications in your world because as a property manager, you understand all the additional issues that come up when the property is going to be for sale. One of the most important issues that you should be concerned about is showing an occupied unit. We understand that most of the time when a client or a landlord wants to sell, frequently it's still occupied by the current tenant. Maybe that tenant's given notice, maybe the landlord's chose to not renew, or maybe even the lease is still in place and the landlord's going to sell the property with a lease agreement, which is completely allowable as long as the lease is part of the closing documents along with the ledgers and the deposits. But showing an occupied unit has some unique complications, some unique obstacles. There's a Residential Landlord Tenant Act, which many of you are aware of, and specifically ARS 331343 talks about access and why a landlord's allowed to access the property and when and how. It also specifically talks about some remedies in another statute we'll get to in just a minute. But the most important part from the showing side is the landlord and their agents cannot access the property to show the property to a prospective purchaser or a prospective tenant, or really anyone else for that matter, unless they deliver a 2-day written notice to the tenant. The problem we frequently see is how do you deliver that notice? It has to be in writing. It can't be a phone call. And you can't have that as an acceptable means of communicating a notice in your lease. That's a prohibited provision pursuant to ARS 331315. So what do? The tenant wants to move or you want them to move. You're going to have to arrange a way to get them a written notice. If you simply mail it to them, you have to mail it certified or registered mail, and you have to add 5 days for mailing. So now it becomes a 7-day written notice. That's pretty complicated. And if you're trying to show a property, you can lose some prospective buyers. But that is still a requirement. So make sure that the listing agent specifically knows about this statute. If you are the property manager, I strongly encourage you to send them an email and CC the owner and let everyone know that this is a serious issue and that they need to list in the listing that it is tenant occupied, and that all the listing agent and anybody who's going to show that property shall not contact the tenant directly. They should go through the listing agent or through you. Also remind your tenant that they have the right to receive a 2-day notice. The next steps are a little more complicated on what does it mean. It says that the law says a reasonable time and reasonable frequency and a reasonable reason. So let's start with time. What is a reasonable time of day for a tenant to be required to show the property? Is that 8 o'clock at night? Probably not. They may have children going to bed. They may be trying to do dinner. Typically, it's business hours, sometime between maybe 9 and 5 in the evening. But you're going to have to be specific. You can't say we're going to show the property on Monday and Tuesday and Wednesday and Thursday and Friday between the hours of 9 and 5 every day next week. Even though you've given them a 2-day notice and plenty of time, that's not a reasonable time frame for them to allow someone to repeatedly come into their home. Frequency is even more complicated. Is it every day? Is it once a week? Is it several times a week? Is it every single weekend? Remember, they have a life too. And showing the property is different when it's tenant occupied versus the seller occupied, who is motivated to show the property as many times as they can so the property can be shown. And finally, you have to have a valid reason. If it's to just check on the property and see what the condition is, that's fine. But you can't do that every day, every week, or probably even every month. You need to have a valid reason, and you need to tell the tenant what the reason is. We're going to have it refinanced. We're going to list the property for sale. You're moving out. I want to show it to another tenant. But you need to tell the tenant why you're coming in. By the way, frequently when I'm talking about this type of notice, people get a little bit confused because there are some exceptions to this statute. There are two specific ones. One is called fire, flood, blood. If any of those events have happened, the landlord can go in immediately because it's an emergency. And the second instance is when the tenant's requested a repair in writing. Then you don't have to give any other notice. There's a penalty statute if you violate that the access statute. It's found much later in the law. It's 33-1376. And there's a penalty if the tenant refuses to allow a reasonable access. There's also a penalty for a landlord if they illegally access the property or have someone else access it on their behalf. Penalty for the tenant is that they can be evicted. And the landlord, that's really the only option the landlord has, is to go file an eviction. You must give them a proper notice that you will evict them if they continue to refuse access, so probably need to give them at least more than one chance. The penalty for the landlord if you illegally access, or your agents, or even someone who's not your agent but was allowed to access the property by your agent, the penalty is 1 month's free rent. That's every single time the person has entered. And those very nice realtors leave a card on the kitchen table letting the tenant know I was here. And so they just count the cards, and that's how many months the tenant is now owed as free rent for the illegal and abusive entry. What are the risks with showing an occupied home, whether it's occupied by a tenant or anyone, is the issue about criminal activity. And I can tell you we've seen quite a few break-ins or thefts of jewelry at that time, or worse, they leave something open and come back later and do a home invasion. And that's a very expensive thing, and most of the time will not be covered by your insurance. So leaving a lockbox or having open houses are something that an owner and a tenant should have a long discussion about. Explain to your owner the problem with lockboxes and the fact that many realtors don't understand that 2-day notice, that 2-day written notice, and the risk of how much money you're going to owe that tenant. The other issue of open houses, remember when we talk about time and frequency, it's not reasonable for a tenant to be required to have an open house for all day or multiple days in a row. That means they've lost the entire ability to use their home at their pleasure for that particular day. So proceed carefully. How about a lockbox on an empty property? I can tell you many of you are not as concerned about this as I think you should, and I'm going to jump right into it because this is one of our biggest fights right now. There are many companies that provide these lockboxes, and the lockboxes are something that can be accessed directly by anyone. My concern is the safety of the people that are in the property and the possession. So if it's completely empty, well, there's nobody else in the unit, but aren't there appliances? Aren't there things in there that a person could steal? And I understand many of you said, but Denise, it's not safe for an agent to go and meet a person out at a home. That's how rapes happen. And I understand that. I also understand this is the way of the future, and the statistics prove that the home gets rented faster when it's more convenient for the applicant to go see the property. I also understand that we have some really great systems out there that will document who has access and when, and that those locking codes expire. But there are a number of risks involved too, and not just the risk that we've talked about, someone coming in and stealing those items, but a risk that someone's going to move in. We've seen quite a bit of that recently, where they just use that code and move right in. Let's look at what the commissioner says about that. Hopefully many of you are aware of this particular rule. And specifically it says that you shall not deliver occupancy or facilitate occupancy until the deal closes. If you're giving access to that home and that happens before a lease is signed, are you in fact delivering possession ahead of time? And I understand it says unless the owner has given written permission. But in your property management agreement, did the owner understand what type of permission you were giving? In the AAR property management, it is discussed, but does it explain really to that owner that someone who we don't know can come in, not a realtor, not someone who has a license, but just some random person can come in and have access through the lockbox? We're going to strongly encourage that you think about this issue and really disclose to the owner what's being used and how it's being used, and that should all be disclosed in writing. So something from the manufacturer of that locks before you use it, so that the owner has an informed consent. And finally, I can tell you I've checked with some of your E&O carriers, and they have said that the determination they have made is that you will not be covered in the event that someone moves in and won't leave, or someone steals items. So look carefully at both your coverage and the company that you're using their lockbox. The next step is, have you had a good conversation with your owner recently? Are they ready? Do they really understand what it takes to be a rental property owner? We think many of them have not. They don't understand the amount of money that it's going to take. They want to own a rental property, and they want the rents to pay for the mortgage. But as anybody in our industry knows, that's only one part of being a rental property owner. Things break, there are mechanicals, tenants move out. Property manager doesn't have any kind of crystal ball to automatically see into the future of what's going to happen. So have a good discussion and document that discussion. Emails is a great way to do that. But you should document all of these conversations with your owner and talk about reserves. Because as we know, evictions are a necessary evil. It will happen, and it is expensive. I think you should be having conversations with your owners up front about what is involved in an eviction, what the process will be, who's going to do that. And so let's jump in. Some of you may not be very familiar with the eviction process. So I would like to spend just a few minutes. It seems like we've had more people enter our field that are licensees in the last about year and a half. And so if you are new to this industry, I'm going to encourage you to come to a boot camp. Make sure you take some specific property management classes. We're going to go through these next slides pretty quickly, but I just want you to be aware that these exist. There are a number of things you have to know before you issue a breach notice. You know what type of notice is given. You need to choose the right notice and include the right language, and then follow the next steps. And be careful not to waive any steps along the way. Understand what the court process is, and then complete the lockout and resolve the next steps, including the deposit. There are a number of different notices that a landlord can send. All of these are governed under the Arizona Residential Landlord Tenant Act. And the key is to learn what type of notice you need to serve and what you need to say in the notice. These are the typical notices that we see: the 5-day non-pay. The first 10 days, the typical breach. The second 10 days when it's repeated behavior. 5-day health and safety is exactly like a 10-day. It's just a more important version of that. Say instead of the house needing to be cleaned up and the yard to be mowed, this is a hoarding situation and it's a fire and health safety issue. An immediate is typically involving a crime, and a non-renewal is when the lease is up and now it's in a month-to-month phase and the landlord decides they no longer want to rent to that tenant. The most common one, of course, is the 5-day non-pay. In the 5-day notice, be specific. Tell the tenant what is owed and how you came up with that total, what the late fees are, how they accrue, and any other charges and how you calculated them. These other charges need to be very narrow. If they're things like broken windows or HOA violations, those really need to be in a different type of notice. We call those a 10-day notice. A 5-day notice of non-payment of rent is typically just for rent and the issues surrounding the payment of rent, so like an NSF. You have the right to refuse a partial payment by the tenant as long as you notify them in writing that you're rejecting that. And you're allowed to do that anytime before court. So if you receive the money in a Dropbox or in the mail, send it back. Don't keep it in your safe, because if you have it in your safe, you have it, and that's the key. Send it back certified mail, and put a notice in there of why you're rejecting the partial payment. Remember, if you want to take a partial payment, you can, but don't accept it without the tenant executing a partial payment non-waiver form. The other typical notices we give are non-compliance notices, unauthorized pets, unauthorized parking. And what happens when the tenant does it again? So they had one dog and now they have 101. What do? You are required to give a second notice. We call a second termination for second noncompliance. In our industry, I also call it second 10-day. This time it's not curable. It says you have 10 days to get out of the property. You don't have the ability to fix it. You just must move. It has to be the same or similar breach as your original notice. So if the first one was for barking dog and the dog was not authorized, you need to now start with a brand new notice saying you have an unauthorized dog that is barking and maybe not picking up the feces. But you need to be very specific about what is wrong in the notice if you end up having to do an eviction for that. 5-day healthy, that's what we just talked about. That's basically an issue on steroids. I would call this a dangerous health and safety situation. If this was just one small area, then you would be giving a 10-day, not a 5-day. Once again, if you want to non-renew the lease or the tenant wants to non-renew the lease, either party has to issue a 30-day notice, at least 30 days before the last rental day of the month you want the tenant to leave or they want to leave. All of these forms are on the AAR zip forms, easy to find and easy to use. We also have them on our website. When you are choosing a breach notice, be specific. What is the violation? When did it happen? What did the tenant not do? And what do you need them to do or not do to fix the issue? When you issue that notice, you have to determine, is it a curable notice or non-curable? You need to have proof that whatever that issue is was not fixed before you're allowed to proceed with an eviction action. Be careful of accidentally waiving your rights. You do this by accepting money after court or accepting the tenant to behave or do something after you gave them a breach notice. The typical examples are tenant comes in and pays you last month's rent and the late fees on the very first day of the next month. You take that money because it's for last month. Now you are prohibited from evicting them for the whole entire next month because on the day you took the rent, the first day of the month, they now owed you the next month's rent. That is a waiver of your right for the entire month, even if whatever they're paying you was for the last month. If they pay you money and it bounces, you did not accept an NSF check. It became NSF later, and you would still be able to move forward. The other issue is allowing them to perform. So you gave them a 10-day notice for an unauthorized dog on the 25th of the month, and now the tenant comes in and pays their rent on the 1st of the month. That is considered a partial payment by allowing them to pay after they received a breach notice for something else. So if what you're doing is you're looking at what am I allowing them to do, and is there something else out there like a different type of breach notice? And if there is, slow down and talk to an attorney before you take any additional steps. By the way, as a real quick note on this, HUD, and if you're accepting any HUD monies like Section 8, that is not considered a partial payment. You're allowed to take money from the housing provider and still require the tenant to pay their portion. There are some new statutes and some new rules involved in this. If you're unsure about subsidized housing, please make sure you go to a special class on this or talk to an attorney about that particular issue. Then you're going to go to court, but that's just the first step. Once you receive your judgment, you are not through. The next step is you are required to issue the tenant a 21-day notice. You are required to mail it, certified mail, return receipt to the last known address and all the alternative addresses after you lock the tenant out. They're able to come in one time and retrieve some items that are listed on a list. I suggest you allow them to retrieve anything they want to. On that first free entry after that, you can require that they pay you the cost to move and inventory before they retrieve the rest of their items. You have the ability to turn off the utilities the day after, but don't forget they have the right to come back and get some its. They pay you the cost to move and store. There's also some statutory exempt items that you have to let them get without paying you anything. If it's after a writ of restitution, it's a 21-day letter. If it's after an abandonment, which means they just skipped out, it is a 10-day notice of abandoned possessions notice. What about the pets left behind? Well, there's a bill actually in front of the state legislature right now addressing this issue, but currently you are required to store, yes, store the pets for 21 days. By the way, pets don't store very well unless they're being taken care of. So we're moving to change the law to allow you to take it to a no-kill shelter or make other arrangements to care for that animal during this period of time. Watch this. We expect it to be a law by about the summer. But currently you're going to have to feed and water and care for that animal for the next 21 days. If you have questions about that, you should speak to legal counsel because it's complicated. And then be careful. If you wrongfully dispose of those items, you can be sued for those particular issues. It's a big deal. And the amount of money that they have in those possessions, which you thought were worth $500, are now worth $50,000 to them. So be careful about disposing of any items. Currently, this law is 21 days after writ of restitution and 10 days after notice of abandonment. I understand that many of you have a provision in your lease that says that you can throw things away if you reasonably believe that it has so little value that it costs more to move it and store it. That is valid only if the tenant skips out on an abandonment. That does not count for a writ of restitution. So the bottom line of our webinar today is make sure you use the right tool for the right job.